You're afraid of estate tax, but you should be afraid of probate. Let me tell you about Martin, who did what a lot of careful retirees do. He watched the news, read the headlines, and saw politicians arguing about taxes. Martin, sitting in his recliner, looked at his wife and said the most expensive sentence of his retirement. "We don't have that kind of money. Estate tax is for rich people. We don't need to worry about this." In one way, Martin was right. He and Elaine were not rich in the way television talks about it. They did not have private jets or offshore accounts or some fancy family office. Martin worked 38 years for an auto parts supplier, and Elaine was a public school librarian. They lived in the same 3-bedroom house since 1989, and they drove cars until the repairs were embarrassing. They had 2 daughters, 1 grandson, and a little over $200,000 in retirement accounts. They had a paid-off house worth $460,000 and a small, random brokerage account. Their total estate was not $15 million. It was not $5 million, and it was not even $1 million. Because of that, Martin believed estate planning was mostly irrelevant. That belief did not hurt him while he was alive, but it hurt the people he loved after he was gone. Martin died in February, 3 years after Elaine, and his daughters found the folder. Every family has a version of this folder, sometimes in a filing cabinet or a desk drawer. Martin's folder was in a plastic bin in the hall closet under old tax returns and a broken flashlight. On the front, Elaine had written one word in blue marker: important. Inside were the documents that were supposed to protect the family. There was a will from 2007 and a power of attorney naming his dead wife. There was a healthcare directive that no longer mattered and a life insurance statement from 2014. There were bank statements from accounts that had changed names 3 times. There was a beneficiary form for an old IRA that left the contingent line blank. Rebecca looked at Anna and said, "At least they had a will." That was the second expensive sentence in this family, because a will is not a magic key. It does not automatically hand the house to the children. A will does not bypass the court, update beneficiary forms, or retitle a bank account. A will does not tell a brokerage firm to ignore its own paperwork. A will is just a set of instructions for the probate court. That is the part most families learn way too late. The federal estate tax was not Martin's problem. Probate was. Let us separate these two things, because people confuse them all the time. Estate tax is a tax problem. It asks if the estate is large enough to owe the government money. For most American families in 2026, federal estate tax is not the primary threat. The federal basic exclusion amount is $15 million per person. If your estate is below that, you may still need planning, but you are probably not worried about taxes. Probate is entirely different. It is a court process. It asks who has legal authority to collect assets, pay debts, and interpret the will. It applies not because you are rich, but because assets were left without a direct legal path. That is the trap. The family thinks we are not rich enough for estate planning. The court says the house is still in the deceased person's name. The family thinks there is no estate tax. The attorney says that does not mean there is no probate. The family thinks there is a will. The judge says, then bring the will to court. Martin's estate did not owe federal estate tax, but his daughters still had to open probate. First, they needed a lawyer, then they needed the death certificate, then they needed the original will. Then they needed a petition, notices, and to identify assets. They had to value the house, notify creditors, and deal with the IRA that had no beneficiary. They had to figure out if the brokerage account had transfer on death instructions, which it did not. Then they had to keep paying utilities, insurance, and taxes while the court process moved forward. And this is where grief turns into administration. Rebecca lived 40 minutes away, and Anna lived in North Carolina. At first, both sisters promised they would split the work, but that lasted about 6 weeks. Rebecca was the one going to the house after work, meeting the attorney, and cleaning the refrigerator. Rebecca was the one finding water in the basement, talking to the neighbors, and paying the bills. She was paying from her own checking account because the estate account was not set up yet. Anna was not lazy, She had 2 kids and a full-time job. But distance changes grief. It makes everything feel less urgent to the person who is not standing in the hallway surrounded by boxes. After 3 months, Rebecca started keeping a spreadsheet. After 4 months, Anna started questioning the spreadsheet. After 5 months, they stopped talking on Sundays. The money was not the biggest problem, but money became the language. They used that language to express the bigger problem. Rebecca thought Anna did not care, and Anna thought Rebecca was taking control. Rebecca thought Anna only wanted her share after the work was done. Anna thought Rebecca was trying to get reimbursed for everything, and the whole time, the estate itself was bleeding small amounts of money. The attorney retainer, filing fees, appraisal fees, and home insurance, property taxes, lawn care, repairs, storage, cleaning, and an accountant. A second consultation because the IRA had become more complicated than expected. None of these costs sounded catastrophic by themselves. That is how estates shrink, not with one giant explosion, but with steady leakage. $700 here, $1,200 there, $3,000 for the attorney, $900 for the appraisal, $400 to keep the utilities on, and a few thousand more. When the first buyer backed out because the estate could not answer. By the time the house sold, both daughters were exhausted. Not devastated, not ruined, just worn down in the specific way that only paperwork after death can wear a person down. And here is what made it worse. Most of it could have been avoided. Not all of it. Death is still death, and grief is still grief. A house still has to be cleaned out. Families still have memories attached to objects that look worthless to everyone else. But the legal confusion, the frozen accounts, and the beneficiary problem, the delayed authority, and the argument over reimbursements could be reduced. If Martin and Elaine had understood one simple truth, the danger was never that their estate was too large. The danger was that their plan was too small. Now let me show you the version of this story that went differently. Across town, Martin's old coworker, Joseph, died 8 months later. Joseph and his wife, Carol, had a similar financial life. Paid-off house, retirement accounts, some savings, and 2 adult children. Not rich, just comfortable, but not wealthy. Joseph also watched the news about estate taxes. He knew his estate was nowhere near the federal exemption. But his attorney told him something that stuck. You are not planning because you are rich. You are planning because your children will be grieving. So Joseph and Carol created a revocable living trust. Then they did the boring part, which is the part most people skip. They funded it. They retitled the house into the trust, and they reviewed their bank accounts. They updated beneficiary designations, and they added contingent beneficiaries. They made sure the retirement accounts did not name a deceased spouse. They created durable powers of attorney and updated healthcare documents. They told their children where the documents were kept. Most importantly, they explained the plan while everyone was still alive. When Joseph died, his son did not have to guess about the trust. He knew, and he did not have to search for the attorney. He had it, and he did not have to ask his sister. They had already heard the plan from him. That does not mean everything was painless. It was just manageable. It means the pain did not have to pass through a courtroom. The house was not trapped in Joseph's name, and accounts were accessible. The beneficiaries were current, and the documents matched the assets. The family had sadness, but they had much less confusion. That is what good estate planning does for a family. It does not prevent death, but it prevents avoidable chaos. There are 3 mistakes that Martin made, which millions are making. Mistake number 1. He confused estate tax planning with estate planning. This is a big error. People think estate means mansions and yachts. Legally, your estate is simply what you own when you die. Your house, your car, and your bank accounts are part of it. Your retirement accounts and debts are part of the family mess. You do not need $15 million to create a problem. You need 1 house, 2 children, and no conversation. Mistake number 2. He thought the will controlled everything. This is one of the most dangerous assumptions in finance. A will is important, but it does not control every asset. Beneficiary designations, joint ownership, and trust documents matter more. The title on the asset matters, and the paperwork at the bank matters. If your will says everything is equal, but your IRA is wrong. The will does not magically fix that bad beneficiary form. If your will gives the house away, but you still face probate, your daughter may still wait months for legal authority to act. If your trust says the home goes to the children, but the deed was never transferred, the trust may be an empty box. That phrase matters. An unfunded trust is an empty box. It looks like planning. It feels like planning. It may even have expensive legal language. But if the assets were never moved into it, the family may end up where they were trying not to go. Mistake number 3. He never had the conversation. This is the mistake that does not show up on legal invoices at first, but it becomes the most expensive. Martin never told Rebecca and Anna why he chose Rebecca as executor. He never told them where the original documents were. He never told them that Elaine was still named on certain forms. He never told them what he wanted done with the house. He never explained whether one daughter should be reimbursed for time and expenses. He never said whether the family should sell quickly or wait for a better offer. So after he died, every missing answer became a possible accusation. That is how families break. Not because anyone is evil, not because the money is enormous, but because silence leaves room for suspicion. Estate planning is not just paperwork. It is a transfer of clarity. Now, what should a normal retired couple actually review? Start with the house. How is it titled? Is it owned individually, jointly, or by a trust? If one spouse dies, what happens? And if both spouses die, what happens next? Does your state allow transfer on death deeds, or would a trust make sense? This is state-specific, so you need local legal advice, but the question must be asked. Second, review beneficiary designations. Retirement accounts, life insurance, annuities, payable on death bank accounts, transfer on death brokerage accounts. Look at the actual forms. Do not rely on memory. Memory is where estate plans go to die. Third, look at your will. When was it signed? Who is named as executor? And is that person alive, capable, and willing? Are the backup people still appropriate? Does the will mention children, grandchildren, former spouses, or assets that no longer exist? Fourth, look at incapacity documents. A durable power of attorney matters while you are alive. A healthcare proxy matters when medical decisions need to be made. HIPAA authorizations matter when your family needs access to medical information. These documents determine whether your family can help you before death, not just after it. Fifth, write a plain language letter, not a replacement for legal documents, not a homemade will, just a letter explaining where things are and who to call, what accounts exist, and what you want your children to understand. The letter will not solve legal problems by itself, but it can reduce panic. And finally, talk to your family, not in a dramatic meeting where everyone cries around the table. It can be simpler than that. I met with an attorney. Here is where the documents are, and here is who I named. Here is what happens to the house, and what to do if I cannot decide. Here is what I do not want you fighting over. That conversation may feel uncomfortable for one afternoon. Avoiding it can make your children uncomfortable for 2 years. Let me bring this back to Martin. Martin was not careless. That is what makes his story important. He paid his taxes, saved money, and maintained his house. He loved his daughters and thought he was being responsible. But responsibility that stops at a folder is not enough. The question is not, do I owe estate tax? For most families, the answer is no. The better question is, will my family know what to do when I am gone? Will they have legal authority? And will the house transfer cleanly? Will the accounts go to the right people? And will the forms match? Will one child feel blindsided? Or will the person doing the work be reimbursed? Will the documents be current? Or will your loved ones inherit a puzzle? That is the real estate planning question. The estate tax makes headlines because the numbers are huge. Probate hurts ordinary families because the numbers are personal. $15 million is abstract. 6 months of waiting is not. A federal exemption is abstract. 2 sisters fighting is not. A tax debate in Washington is abstract. A daughter searching for a will before the weekend is not. Martin spent years afraid of the wrong thing. He thought the danger was the government taking too much. The real danger was he left his daughters too little clarity. And that is the lesson. You do not build a plan because you think you are wealthy. You build one because you know your family will someday be grieving. A good plan does not have to be fancy or use every trust. It does not have to turn you into a tax strategist, but it does need to be current and match the assets you own. It needs to account for state law and name the right people. It needs to avoid unnecessary court involvement where possible. It needs to be understood by the people who have to carry it out. Estate tax may never touch your family, but probate might. Outdated beneficiary forms, an unfunded trust, or a silent parent might. Do not ask only whether your estate is big enough to be taxed. Ask whether your plan is clear enough to be followed. The most expensive inheritance is not always the one with the tax bill. Sometimes it is the one wrapped in a folder labeled important, full of documents that no longer know what your life became.